The obligations of an NDA or non-disclosure agreement for any small business includes making sure that when you disclose information that's confidential or a trade secret to someone else, that other party, the recipient, is going to maintain the confidentiality of the confidential information or the trade secrets. And so that oftentimes means that that other party, the recipient, can't simply leave documents on the conference room table out in the open for everybody, that they can't just go and talk about it within their own organization with everyone. That confidential information should be disclosed only to those that have a need to know, as well as when they do have a need to know, making sure that those people have also signed confidentiality agreements that are strong and enforceable. Because certainly if I'm a recipient of confidential information and I tell one of my employees this confidential information, if they're not bound to a confidential information agreement or an NDA as well, they don't necessarily have any obligation to maintain that confidentiality. So it's really important to make sure it's need to know, that they've signed an NDA, and that it's not just been left lying around, or that it's not password protected if it's on a computer system or a network. There are also some exceptions where one can disclose information if they're subpoenaed or there's a court order for them to disclose that information. But what I like to have in a good NDA is the obligation of the recipient to tell the discloser, the person who originally is disclosing the information, when they've gotten a subpoena, and allow that disclosure to then attempt to protect against the further disclosure of that information, or to make sure that it's only submitted under seal, or something along those lines. So those are important aspects of what's included in an NDA, what the obligations are, and what the possible exceptions are in a well-drafted non-disclosure agreement.